You are Walkin Hernandez.
Sir.
Mr. Hernandez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to 7000 Gulf Freeway, and another officer had advised that the defendant would sleep in the driver's seat of the vehicle. The vehicle was on and running, and the officer observed a container of beer in plain view in the center cup.
Caught asleep behind the wheel with beer and a margarita-to-go. Judge is about to shut this down hard.
And the officer observed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and the defendant admitted to consuming beer, but did not state the amount. The officer observed a 12-ounce mixture of Ultra cold to the touch and a plastic bag labeled margarita-to-go with a straw sticking out of it, mostly consumed, and an open pack of beer in the back seat. The standard field sobriety tests were performed, HGN 6 out of 6. Walk and turn and one leg stand were not performed due to the defendant claiming he had one bad leg. The defendant was read the DIC and declined to provide a sample, and a blood search warrant was signed and executed.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has any prior DWIs, please?
Yes, Judge. I see no prior DWIs.
I would venture a guess that it's damn elementary that you're not supposed to have alcohol in the car. I am now taking away your privilege to drive. You will be signing an affidavit with me today, promising me you're not going to drive, and I don't give a rat's behind what is going on in your life. If I find that you drive, and I don't care if there's a burning building and you have to say 50 children.
Refused the test, but the evidence is stacked. Beer, slurred speech, and a warrant for blood. What would you do if you were the judge? Drop a comment.
Do not drive for any reason. If you have a problem with drugs or alcohol, you better address it, because if you don't, I will do it for you. And I promise you're not going to like the way that I do it. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find anything, you're going to stay with me. No more PR bonds.
Your Honor, will he have the opportunity to have an interlock system on his vehicle?
No, he can't drive. I'm not going to let him drive. I mean, he's got multiple open containers, all have consumed allegedly. No. I mean, and I would think that, you know, it's a privilege. And if I get that he understands the awesome privilege at a later date, come back and we can talk. But at this point, no. I will have you come up here, swear to us that you're not going to drive. After that, I'm going to get you the Victoria sign and reset. After that, what is your name, please?
Takia Smith.
I'm sorry?
Smith.
Ms. Smith. You will get to Ms. Smith where she will give you your bond conditions. After that, you'll be free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games, you pick up a new case, you endanger.
No more driving. Not even to save kids from a burning building. Asterisk, the judge just made it crystal clear. Driving is a privilege, not a right.
19, is there a possibility that we can present evidence to the court to permit the interlock?
I am always all ears, but at this point, with all that's in that car, no. But come back at a later day, show me, because it is a privilege. It's not a right. You want a right, take your Dodge Patas and take, but it's an awesome privilege, and that's what it is. Show me how much of an appreciation, proactivity goes a long way, and then we can talk. All right? Yes, ma'am.
Judge, just really quick, tracking no drugs, no alcohol, is it randomly?
Please, on all DWIs, Randy Gaze.
And
Yeah.
it's public device or not?
No,
Okay, right.
it's a first. Good morning, Mr. Sarmiento.
Ese señor Sarmiento.
You were,
Señor Sarmiento.
you were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Si no puede ocupar uno.
Yes, Judge.
I'm going to go slow.
Yes, Judge.
Más escuchar.
On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced themselves as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement to know, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He doesn't know, he didn't say he know he stole it. He just didn't know him, did not give
So
permission.
you're telling me that he's in a car, he doesn't know the driver, and
Your Honor, the complainant just said that in regard, he did not know the defendant, did not give.
I understand that, I get that, but, so he's, he's a passenger in the car, and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't know. When a criminal trespass requires some kind of like notice and, hey, man, you know,
So the trespass was the driver driving into the area and he was the.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that, like, how would he know that the car is stolen? Right? You got to give me something that, it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, further, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was. One moment.
a scratch on the hood.
Signs of theft that would lead a reasonable person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, okay. I thought you also said that the driver and.
No, Your Honor, and it may be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there's enough there that a reasonable person would believe
That the.
he's in a stolen car.
Yes.
So the steering column was
Was broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
Un desarmador podía apagar el vehículo.
See, I don't know, you know, because when I was young and dumb and 17, and, you know, my friend had a CJ7, you know, you ever been in those Jeeps that are just jalopy Jeeps, right? They always broke down. They always had a problem. We always, you know, Jimmy rigged it as well, you know?
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
That no difference to me.
That goes to the element of without, for the criminal trespass, it goes to with knowledge that it was,
No, I'm sorry. I'm gonna find no probable cause.
Yes, sir.
Porque no hay razón purgatoria.
Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir. Mr. Sir, you're charged with theft, aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 12th, 2025, the officer responded to an HEB in Harris County, Texas, in regard to the theft of an employee. The officer made contact with the complainant, the loss prevention investigator. The complainant stated the defendant was an employee of HEB, and the loss prevention employee was notified by a store manager that the defendant was taking Red Bull into the pharmacy without paying, drinking the Red Bulls, and then throwing it away. These acts were verified by video, and the complainant researched the defendant and noticed that when the defendant left his shift, he would have a bag of unpaid grocery items, which select items throughout the store, bring the unpaid items into the pharmacy, wait until the end of his shift, bag the products, and then leave the pharmacy without attempting to pay for the merchandise. The complainant observed the defendant take items without paying in 7 different days. The total was approximately $368.38.
Sir, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to any HEB. Do you understand? If you violate these conditions, you pick up a new case, I'm going to put you in jail. No more PR bonds. You understand, sir? Are you working now? Do you have an income?
I am studying for my board exam. So no,
Study for board exam for what?
actually,
Really? Not a good way to start, sir. You know, really. Look, I'll give you a lawyer today. Don't pick up any new cases. You got to understand that you got your future ahead of you, man. You want to be a nurse and now you got, come on, really? I need you to fill out an application for me. Fill it out. Let me take a look at it. I'll give you a lawyer today. Just make smart moves. It's not hard, you know, really. Come on.
Judge, was that responsible?
Yeah. Do you mind filing no back HEB, please? Any HEB.
Yes.
All right, Judge, counsel is approaching on page 7. Hernandez, come on up.